Welcome back. As you know, my name is Brian Burkhoff, and this is the New Jersey Workers' Compensation Conversation. Today, we'll be talking about defenses to New Jersey workers' comp claims. These will be issues that you're probably dealing with daily in your claims. So, this could be extremely helpful in obtaining a dismissal or reducing the settlement in the particular case you're working on. Right now, I'm going to produce a list next to me of all the potential defenses that we have in New Jersey regarding workers' compensation claims. I could probably make a dozen videos to address all these different issues, but we're only going to address a few today. In future videos, we'll dive into more specific issues of defenses such as the Fraud Act or other extremely detailed defenses. So let's begin. There's a few defenses that you can investigate at the very beginning of the claim that I feel important to talk about today. They include the issue of employment, notice, jurisdiction, and the statute of limitations. It's extremely important to have the employer, the adjuster, and your attorney all on the same page from the very beginning of the claim to ensure all information is distributed and that these defenses can be properly investigated. Without great communication, we may not be able to secure dismissal like we would like. So, with respect to employment, the issue is often straightforward. The claim petition is filed against Company A, but in fact, petitioner was never employed by them for various reasons. Perhaps he was an independent contractor, or maybe he actually worked for Company B that was working on the same job site. Whatever the reason may be, I'm frequently able to secure dismissals at the beginning of the case by filing a motion for lack of employment. After the motion is filed, we can ask the petitioner's attorney to bring in the correct employer, and once the other employer accepts employment, we'll be let out of the case without much cost associated. But this is something that needs to be checked at the beginning of every case. As attorneys, we rely on the employer to provide information to confirm whether or not the petitioner actually was an employee of theirs. Now, moving to the second topic, we must deal with the issue of jurisdictional issues at the beginning of the case. Sometimes cases are filed in New Jersey when they should be a New York or a Pennsylvania claim. For example, say the petitioner lives in Camden, but he works in the Philadelphia office of his company. He was hired while present at that Philadelphia office, and the company only works out of Pennsylvania. They have no New Jersey work. When this accident occurs in Pennsylvania and has all the other ties only to that state, other than the petitioner living in New Jersey will not have jurisdiction. In that instance, we'll file a motion to dismiss for lack of jurisdiction at the very beginning of the case. So, in that instance, we would want to deny the claim altogether since there's no jurisdiction. But we may have to litigate the issue slightly to say that petitioner will probably argue that he can have dual jurisdiction perhaps, or that this should continue as a New Jersey claim. So it's important to get the ball started, the ball rolling early in situations like this. Another extremely effective defense early on in the case is the statute of limitation. In traumatic claims, the petitioner has 2 years from the date of their last benefit to file a claim, or 2 years from the date of the accident if no benefits have been paid. So, if petitioner slipped and fell while doing his job, and his employer authorized him to go to the emergency room, but that was the only date of treatment, he would have 2 years from that day to file a claim. If he waits 3 years, we would then file a motion to dismiss and say that the petitioner has violated the statute of limitations and that our case should be dismissed with prejudice. It does not occur very often where the petitioners file claims so far after they have actually experienced a traumatic accident because, as you know, they're looking to get their benefits and money in their pocket. However, this does occur. Therefore, we must ensure we investigate the claim when it's first provided to us, and we do not want to pay any benefits when we think that they may not be entitled to them. So specifically, we want to ensure that we don't restart the clock on the statute of limitations by authorizing a new visit if it's been 3 years since petitioner has gotten any benefit. Now, occupational claims differ greatly from traumatic claims in terms of the statute of limitations, and frankly, it's a more difficult standard to prove. So in order to obtain a dismissal in an occupational claim, it often requires the testimony of the petitioner. But they violate the statute of limitations in an occupational claim when more than 2 years has passed since the date that the petitioner, 1, knew the nature of the disability, and 2, knew the relation to its employment. So to assert this defense, we would either need medical records from more than 2 years before the claim petition was filed, stating that the petitioner was diagnosed with an L4-5 herniation, for example, and at the visit, he told the doctor, I know I hurt my back from doing my repetitive lifting at work. Now, if we have those facts, it's fairly straightforward, and we can file a motion to dismiss. However, it's often less clear. So this defense is actually limited to the specific medical condition noted. So in the example I just gave, we wouldn't be able to bar the lumbar spine overall. It would be limited to the L4-5 herniation, which he was made aware of 3 years ago. Thankfully, there are some decisions that help us that say medical certainty is not needed. It's only necessary that the petitioner was aware of facts that would make a reasonable person alerted to the possibility of a claim. And finally, it's also helpful that the petitioner does not need to have a medical professional say their condition is related to their employment. So in the example I previously discussed of the L4-5 herniation, it could be enough for him to say, I knew that my work was significantly causing me back pain, without the doctor explicitly stating, your herniation is related to your employment at company A. So the defenses we talked about so far in terms of employment, jurisdiction, and statute of limitations are effective ways to secure dismissal with prejudice and permanently close the claim. The last defense I want to talk about is that of notice. This is a frequently used defense by respondents. I've had several files where I get referred a case and the adjuster says that the claim petition is the first notice of any accident happen. So how does lack of notice practically impact things in our cases? It's important to note that this defense is only for traumatic claims, so it doesn't apply for those that are occupational in nature. We also have to make sure we know that notice can be verbal or written. We can look at Section 17 of the statute to discuss how the notice provisions apply. Overall, it's actually a very confusing statute. So you should know that notice is considered sufficient if it's provided within 30 days of a traumatic accident. But you might be wondering, well, what happens after 31 days? If notice is provided after 30 days, the respondent can obtain a dismissal of the case. However, we have the burden to prove that this delay in providing notice caused prejudice to us. So a frequent example that we use is, say that the employer has video cameras that would have been able to record the alleged accident. Say there's a slip and fall that occurred into a kitchen. If the video cameras recycle their film every 30 days and the petitioner doesn't provide notice until 40 days, we would be prejudiced because now we have no way of looking back to see what occurred on those films. If he had properly provided notice quickly, we could have gone back, seen the footage, and defended the case as needed. However, once the petitioner fails to provide notice after 90 days, we don't have to prove anything. The employee would then lose and their case should be dismissed. Now that's from a statutory perspective. In practice, the petitioner is always going to say, I told person X about my accident. So it's important for us to speak with the employers and find out, is this person who allegedly was told about this accident in agreement that they received notice, or are they disputing it altogether? Nowadays, most of our clients are writing down when there's been an accident. There's forms that can corroborate this. So if an accident was truly reported, there should be good documentation. But there are times when we get into a he said, she said, and we would then need testimony and it becomes an issue of credibility. But we need to continually push the issue of notice to ensure that claims are reported timely so we can investigate them as needed and quickly get petitioners to our doctors if necessary to address treatment and causation. So, Overall, we touched on 4 important defenses that can be addressed at the very beginning of our cases. We're going to continue in upcoming videos, dive into some more in-depth defenses that we can make. And if you have any questions about this topic, please feel free to reach out to me personally, and I'd be happy to address on an upcoming video or in a conversation whatever issues you may be facing. My contact information will follow this video on a slide, and I'll be happy to discuss things with you. And with that, I hope you have enjoyed our compensation conversation, and I look forward to talking again soon.